Mr. Abdulaziz and Apex Global Management Limited.
This appeal arises out of a joint venture between Apex, a Seychelles company owned by Mr. Almhairat, and Global, a British Virgin Islands company owned by Prince Abdulaziz, the Prince, Mr. Abu Ashi, and Mr. Sabha. Apex and Global set up an English company, Faisal, and then fell out badly. In December 2011, Global issued a petition against Apex, Mr. Almhairat, and Faisal, seeking share purchase orders and other relief. 10 days later, Apex issued a very similar cross-petition against the Prince, the Prince's father, Global, Mr. Abdulaziz, and Faisal. Apex concluded a claim for just under $6 million US, which it contended was owing by the Prince, but which the Prince said he had repaid. The two petitions, which each included allegations and counter-allegations of seriously unlawful misconduct, were ordered to be heard together. In July last year, Mr. Justice Voss directed that each party file and serve a disclosure statement certified by a statement of truth to be signed personally. The Prince, who had unsuccessfully objected to this direction, failed to comply on the ground that members of the Saudi Royal Family were bound by a so-called protocol, which prevented them from taking part in litigation or signing court documents. Apex then applied to Mr. Justice Norris for, and obtained, an order that unless the Prince complied with the direction, his defence be struck out and judgment entered against him. The Prince did not comply, and Apex applied to Mr. Justice Norris for, and they obtained again, judgment in its favour. The Prince then applied for a variation of Mr. Justice Voss's order and for relief from sanctions. Mr. Justice Mann refused to vary Mr. Justice Voss's order and rejected the application for relief from sanctions. In July 2014, Mr. Justice Hilliard refused an application for summary judgment on the question of whether the $6 million had actually been repaid. Meanwhile, the Prince appealed and appealed unsuccessfully against the decisions of Mr. Justice Voss, Mr. Justice Norris, and Mr. Justice Mann to the Court of Appeal. He was given permission to appeal to the Supreme Court on the terms that he paid $6 million to his solicitors to abide the order of the court. The Supreme Court dismisses the Prince's appeal in a judgment given by me, with which Lord Sumption, Lord Hughes, and Lord Hodge agree. Lord Clark dissents. The standard form of disclosure by a party appears to require personal signing by that party. The orders made by Mr. Justice Voss, Mr. Justice Norris, and Mr. Justice Mann were each arrived at on a correct approach in principle and a careful consideration of the competing arguments, and are individually unassailable. It is hard to say that the consequences of those orders are disproportionate, because it's important that a litigant obeys court orders. If he refuses to do so, despite the imposition of a sanction, the enforcement of the sanction is almost inevitable. There are no special factors which justify reconsidering the original orders. The strength of a party's case on the ultimate merits of the proceedings is generally irrelevant when it comes to case management issues of this sort, though there may be an exception where a party has a case the strength of which would entitle him to summary judgment. The Prince would have a good prospect of establishing that the $6 million was paid as he contends in his defence, but his prospects cannot be said to be any higher. Although the question whether the Prince has paid the $6 million may arise at trial in these proceedings between the other parties, it's inherent in a default judgment that claimants will sometimes obtain relief to which it may subsequently be shown they were not entitled on the merits. This court should be very diffident about interfering with guidance given or principles laid down by the Court of Appeal when it comes to case management and application of the rules. Lord Clark would have allowed the appeal on the basis that justice requires that the Prince be allowed to challenge the claim against him, and all parties would be protected because the court would be able to resolve all the issues between the parties. There's a postscript. Since the hearing of the appeal, there have been further developments which may, and I underline the word may, justify reconsideration of the issue which we have decided. If in the light of these developments, revocation or modification of any of the orders which I have described is appropriate, then that is a matter which should be raised before a judge of the Chancery Division, who should also be responsible for deciding how the $6 million should be dealt with. The court is now adjourned.